Welcome to The Insurance Lawyer, the podcast where we discuss topics concerning claims and lawsuits between insurance companies and their policyholders. I am your host, Evan Schwartz, founding partner of Schwartz, Conroy, and Hack. The firm represents business and individual insurance policyholders in claims and lawsuits against their insurance companies, helping policyholders get their claims paid. Today, I have the privilege of having my partner, Matt Conroy, on the podcast, and he's going to help me talk about civil insurance fraud, which is an area that we encounter in many aspects of both our individual claims and our business insurance claims. Matt, glad to have you here today.
Happy to be here, Evan. As Evan has said, this is something that we see in our practice pretty frequently. There are a lot of issues that arise when you're talking about insurance fraud in general. In the civil context, one of the first things you probably want to consider in terms of defending in a civil insurance fraud claim by a carrier are the implications of criminal proceedings arising as a result of those claims or accusations.
What do you mean by that, Matt?
Well, the first layer would be for a practitioner to really understand, where the alleged fraudulent conduct comes from and what type of client might be prosecuted as a result of the complaints being made by the carrier. And there are a lot of different things to take into consideration. The type of insurance that we're talking about, it could be homeowners, it could be disability, it could be auto, it could be life. So when you're evaluating a claim, whether it's a defense that was put up by a carrier as a result of a claim that your client made, or a lawsuit that you filed on behalf of your client, that's one instance. It may be a matter where you've gotten a declaratory judgment complaint or a fraud complaint seeking monies returned from a carrier. And, whichever type of claim or litigation is involved, you want to take into consideration the type of client you have. Is it an individual? Is it a corporation? The size of the claim, the nature of the claim, and the type of fraud that's being alleged, whether it's a conspiracy or whether it's truly a criminal act. And if you find yourself with a matter that has actual criminal implications, that's something where as a client, you probably want to get a second lawyer who is primarily a criminal lawyer. If you're a civil defense litigator, that's probably something where you want to certainly consult with and possibly retain someone who's well-versed in criminal law as it respects to that particular insurance fraud.
Let's be a little bit more specific about sort of looking at that distinction as to when the words fraud are going to connote something that is more serious, let's say, where there may be criminal implications as opposed to just looking at the civil remedy. So let's talk. So, for example, in our practice, one of the things we see on the individual benefit side quite often is an effort for an insurance company, either in response to a claim or when they bring their own lawsuit, where they want to rescind the policy because they claim that the insured lied on their application. Now, that also comes up in the business context as well. But I guess my question is, when the company is seeking to void the policy and pretend as if it never existed based on claims of fraud, is that a scenario where you might typically think that criminal implications are involved?
That's probably the least likely area. When you've got a civil dispute between an insurance company and a policyholder, and the insurance company is looking to avoid its obligations because of let's just call it something contained in the application that isn't necessarily true. You're going to get into the civil issues of whether it was an intentional omission, whether it was something that is material, whether the client knew it was false at the time it was made, and obviously issues such as the timing as to how much time has elapsed between the time the representation was made and whether or not that could be voidable. But in general, we don't see a lot of criminal prosecution or investigation of omissions or misrepresentations contained in the application itself. It's possible if it's something that is egregious enough, but oftentimes it's an oversight, and many times, especially in the disability space, it's not necessarily even the client who filled out the applications, and you have other parties involved like brokers. So from a defense perspective, when you're pursuing a claim and you get a response that there's an omission on the policy application, that's not something necessarily where I would run out and engage a criminal lawyer to look at. But if it's something where there's any kind of pattern or where the misrepresentation involves a substantial amount of deceit, that is something where I would consider bringing in criminal counsel, just to be sort of more specific about that. If it appears as though your client has actually staged a policy and a job disability in an effort to illegally obtain disability benefits, and there are, more than one fact involved where you've got, a history of medical records or medical treatment that weren't disclosed and misrepresentations made by the client to reviewing doctors or physicians, and then continued falsehoods advanced by the client to the carrier in the claims process. That's something where you're not looking at one simple misrepresentation, but maybe a series of things that could attract the interest of a prosecutor.
Okay, so what about the situations that don't involve material omissions or intentional omissions or intentional misrepresentations on an insurance application? What other areas do you see in the practice where the specter of criminal liability is much more significant when a civil case comes in the door, or you're in the middle of handling a civil insurance litigation where there may be some allegations of fraud, and you look and you say, oh, these types of cases where the government's pretty interested?
Well, certainly in the context of workers' comp and no fault in Medicare and Medicaid, you see civil actions that are commenced by carriers or by even by divisions of the government for civil restitution that ultimately precede a criminal prosecution by the federal or the state government. When you're representing medical providers and even to some extent patients or people involved with the procurement of patients in the no-fault space, that is something where lawyers should take special care, because there certainly is communication between carriers and investigatory agencies of the state and federal government, and where you have allegations being made publicly in civil lawsuits, either in the state or federal courts. Those are areas of special interest where the FBI, the Attorney General's office, joint task forces, and state and federal prosecutors have access to and often present information to grand juries based off of an initial starting point that was laid out by the plaintiff carrier in those cases. So as either as a litigant or as an attorney representing professionals, that is something that would require certainly special care in how you handle it, what your plan is in terms of litigating or settling, how you craft and deal with settlement agreements in terms of confidentiality, and what you ultimately do with your client in terms of making statements by way of affirmation, affidavit, or in a deposition.
Okay, so now that we've gotten through the issues where criminal liability can come up, let's talk more about the civil fraud aspects of some of the matters that seem to come across our respective desks, and the situations where the potential for fraud exists, if I could say that. So maybe you can give me some examples.
I can. You want to start with the idea of what it is that constitutes the fraud in any particular case. As in any fraud case, insurance fraud is no different in that it requires a material misrepresentation, which results in damage to the carrier. And it requires reliance on the part of the insurance company on that representation. And so there are different types of fraud that you see, but all of them involve the commonality of the claimant misstating some material fact to the insurance company, which they rely on and ultimately make the payment. And the things that we see, you see misrepresentations being contained in a proof of loss or in a claim form that's submitted in the context of a homeowner's claim, of a fire claim. Even in the medical space, you'll see a misrepresentation being contained on a bill, for example, in no fault that's being sent to a carrier. And that misrepresentation can be that the services were performed at all, that the services were necessary. And we've even gotten to the point where a misrepresentation can be that the professional corporation that's listed as the provider of service is eligible for reimbursement under the particular system of reimbursement. You also see fraud claims that arise from what ends up being the verification of information that's been supported in a claim. And that could be an examination under oath. It could be a sworn statement, written statement provided by the claimant. It could be inflated or fabricated numbers in connection with that claim, or it could potentially be information provided to a third party, such as an IME doctor, in a variety of types of claims, long-term care, long-term disability, or no fault. Those are basic areas of interest when you're talking about the misrepresentation itself that's going to support a fraud claim.
So there's a lot of ways this comes up, but I would comment that fraud is a very, very, very tricky area of the law, and there are all these elements that need to be proven to prove that one side or another actually engaged in a fraudulent act. And in the insurance company context, when you're dealing with insurance companies, besides proving that someone actually did something with intent to deceive the insurance company, which is always a huge battle and often winds up at a potential trial, the other thing that you see through the discovery process and trying to figure out whether fraud has actually occurred with an insurance company is whether or not they actually relied on the information that they claim is false to their detriment and then were induced to pay money. And a lot of times there's a whole world of information that contradicts a claim by an insurance company that they detrimentally relied on this alleged misrepresentation to induce them to make payment.
Yeah, it's a great issue. Reasonable reliance is an element in the plaintiff's prima facie case to establish fraud. And there's a great case out of Texas, maybe 6 or 7 years ago. Allstate was the plaintiff. They had sued a series of chiropractic companies that were providing services really throughout the Houston and Dallas areas. And the case ultimately went to trial. Allstate prevailed, and the decision was reversed on appeal. And the appellate court in Texas determined that Allstate had failed on the issue of reasonable reliance, primarily because of the testimony of a claims adjuster who, in sum and substance, testified that when they received claims, they didn't accept the representations contained in the bills or in the medical reports, but they sent them out for review to their own people to determine whether or not they were medically necessary. And so the court found that Allstate could not claim that they reasonably relied on what was contained in those reports because the facts contradicted that. The facts indicated, as is often the case, that when they received the information, rather than saying, yes, we believe this is true, we're relying on it, and we're paying because of it, but instead sent it out to another group of physicians that they hired to say, can you review this and determine whether or not these services were medically necessary and should we pay these claims? And that's a pretty interesting case. It's not necessarily been followed across the country. There are a lot of different systems in different states that are sort of similar to the Texas system, where a physician or a chiropractor or any healthcare provider is able to take an assignment of benefits or stand in the shoes of the patient to bill the insurance company. And this issue of reasonable reliance is an interesting and sort of fact-sensitive issue that comes up in many of these places. But I suspect that that's something that we'll see more of in the future.
When you are evaluating a case and the allegations of fraud are pretty well developed and you think that there's a real risk to your client, how do you typically, manage situations like that? Or can you give us some examples of how you would sort of manage situations like that?
Well, that's an interesting question, and it brings up a lot of, fairly heady issues. One of which is when you're confronted with a set of facts where your client appears to have made intentional misrepresentations of critical information to someone who ultimately lost money as a result, you've got some real concerns as to what your conduct is going to be as far as making representations to the court or to your adversary, real issues as to how you counsel your client to either advance that position or contradict that position or change his position. It's deep water that you're treading in when you've got a client who's made statements under oath or signed documents where he or she is now going to change their position, and you're going to stand in front of a court and advocate that new position. These are things that raise some ethical issues. They are matters that raise some potential criminal issues for the client and conceivably for yourself. At a minimum, when you've got a client who appears to have engaged in conduct that could fit squarely within the ambit of fraud, that's something where the lawyer should take extra steps to make sure that they are not doing anything to further that fraud. But also understand that, that client needs proper representation, maybe more than the client, who's not made a misrepresentation. And so a lawyer would be well cautioned to take special care and to make sure that that client is being represented zealously yet ethically.
Well, what about from the corporate side, where you have corporate actors in insurance claims and you believe that there is some evidence of some fraudulent conduct that is going to significantly impact whether or not the entity is going to recover monies from the insurance company, or the defense scenario where they're being sued for fraud and you believe that there's some exposure? Is there any different type of an approach there?
Well, you have better options when it comes to a corporation. Once you're in litigation, you're dealing with multiple levels of witnesses, and you're talking about people who have corporate information as opposed to personal information. In there, you have the sort of added layer of corporate counsel or in-house counsel who potentially can help you deal with those issues. As the lawyer representing the corporation, you need to take some special care when it comes to understanding potential impacts to particular individuals that might arise above and beyond the corporate context. And those people probably should be advised to seek their own counsel, or at least co-counsel, to help navigate that. But certainly special care needs to be taken. But you do have better options, oftentimes with what is deemed to be fraud that's engaged in by the corporation itself.
Very, very interesting. I'm going to say that Matt, both for himself and Matt and I together, have over the years confronted and handled both claims and quite a few lawsuits where fraud has been alleged by one party or another in an insurance recovery context, and that they are really, really challenging factually. They're challenging factually. They have interesting legal issues. And there are cases where, clients have real risk, but there are also cases where insurance companies like to bandy about fraud and use fraud as a club a little too liberally, in my opinion, and in order to gain the advantage for which they seek, which is to save themselves money. So that's just a brief sort of primer on what to be looking for and what can come up in the context of an insurance fraud claim. And I thank Matt for being here, and I thank you all for listening today. And if you like the podcast, make sure to leave a review and subscribe so you don't miss an episode. You can visit Schwartz, Conroy, and Hack PC website at www.schlawpc.com. That's schlawpc.com for more information. I'm the insurance lawyer. Have a fantastic day.